what really shocks me? Most people in the UK don't have a valid will, and even when they do, half of them get it wrong. One missing signature, one dodgy witness, and suddenly your entire estate could end up in the wrong hands. So today, we're breaking down exactly what makes a valid will, who can make one, how it must be assigned, and the easy mistakes that could undo everything. I'm Sarah, founder of Your Rights Matter, and this is where we make the law clear, simple, and actually useful. Okay, let's start with the basics. Who's legally allowed to make a will, or as the law calls them, the testator? Well, under Section 7 of the Wills Act 1837, anyone aged 18 or over can make a will, provided they're of sound mind. Okay, so what does sound mind mean? The classic test comes from the case of Banks v. Goodfellow, 1870, and honestly, it still sets the standard for today. Put simply, the testator must understand they're making a valid will that takes effect after their death, know roughly what they own, their property, money, and assets, and 3, understand who might reasonably expect to benefit, like family, dependents, or partners. If someone doesn't meet that test, say they're suffering from serious dementia or heavily medicated, the will can be challenged for lack of capacity. A good modern example is the case of Key, 2010, where an elderly widower made a will just days after his wife died. The court found he didn't have capacity. His grief meant he couldn't fully comprehend what he was doing. So what's the lesson here? Emotional distress can cloud capacity too. It's not just about medical illness. Okay, let's get into the mechanics of how a will becomes valid. Section 9 of the Wills Act 1837 lays out the golden rules. Think of them as the 4 pillars of a valid will. Number 1, it must be in writing, typed, handwritten, even printed, but it has to be written down. Number 2, it must be signed by the testator, and at that signature must show they intend the document to be their will. Number 3, the signature must be, or acknowledged, in the presence of 2 witnesses. Both witnesses must be present at the same time. And number 4, each witness must then sign the will in the presence of the testator. Simple? Yes, but it's shocking how often people get this wrong. Take the case of Gruffman, 1969. The witnesses signed separately, one after the other, not together. The will was declared invalid. It doesn't matter if the will looks valid. If the signing process doesn't meet these formalities, it fails. Okay, so let's talk about witnesses, because they can make or break a will. Witnesses must be 18 or over, have mental capacity, not be blind. Obviously, they must be able to see the testator sign. But here's the big trap. If a witness or their spouse is named as a beneficiary, their gift fails. That's Section 15 of the Wills Act 1837. The will itself is still valid, but the gift to that person is void. So if your lodger witnesses your will and you leave them £10,000, sorry, they get nothing. So here's the thing, wills aren't permanent. They can be revoked or cancelled or altered. There are 3 main ways a will can be revoked. Number 1, by making a new will. The new one usually says, I revoke all former wills. Number 2, by marriage or civil partnership. This automatically revokes any previous will unless it was made in contemplation of that marriage. And number 3, by destruction, physically tearing or burning it with the intention of revoking it. It's that last bit that's key. It has to be done deliberately. If your will is destroyed accidentally, say your cat knocks over a candle, it's still valid if a copy can be proven. Sometimes people make changes directly on the will, scratching things out, writing in new amounts, etc. However, here's the problem. Any alteration made after the will was signed and witnessed isn't valid unless it's re-signed and re-witnessed. So for example, if you change £1,000 to £10,000 later, that change has no legal effect unless you re-execute the will properly. Then there are conditional wills, where the will only takes effect if a condition is met. For example, this will only applies if I die before my trip to Italy. They're valid but risky, because if the condition isn't clearly triggered, the whole thing might fail. Here's an old school but still relevant exception, privileged wills. These apply to members of the armed forces on active duty and mariners at sea. They can make informal wills, even oral ones, without following all the formalities of Section 9. So for example, a soldier in combat might say, I leave everything to my sister or everything to my cousin, and it can count as a valid will. It's rare, but still recognised under Section 11 of the Wills Act 1837. Finally, what happens when mistakes slip in or a revoked will needs to bring it back to life? Well, rectification under Section 20 of the Administration of Justice Act 1982 allows the court to correct a clerical error or misunderstanding of the testator's instructions, but only if there's evidence of what's intended. For example, the solicitor accidentally leaves out a beneficiary's name or mistypes an amount. Revival, on the other hand, is when an old will is brought back into force after being revoked. That can happen if the testator re-signs it or clearly intends to revive it in a new document. So to wrap up, a valid will isn't about fancy wording or expensive lawyers. It's about getting the fundamentals right. Capacity and intention, proper execution and witnesses, and clear revocation and updates. If you get those right, you protect your wishes and saved your loved ones from chaos later. Again, I'm Sarah from Your Rights Matter. If you found this helpful, hit subscribe and remember, the law doesn't have to be hard, and together we can make it easy. I'll see you on the next one. Bye-bye.